Hello, everybody. I am the last-minute replacement for our host, Jack Potter, who had surgery, and his voice isn't quite up to par, so please forgive me if I have a script that I screw up. Okay, so first of all, we wanted to, on behalf of Red Bear Healing Home Society, welcome and thank you for attending our second Truth and Reconciliation Cafe. My name is Mel, I'm on the board of directors, and we're especially glad to have live stream participants tonight as well. Thanks to everybody who's joining remotely. And this recording will remain available online after the event as well for those who are unable to join us tonight. Okay, we're happy to be back at Dalhousie University in the Student Union Building where we held our first cafe event located on unceded, unsurrendered Mi'kmaq territory. Red Bear Healing Home started about 10 years ago. It's a nonprofit to provide free voicemail to people who are experiencing poverty. I have some of our board members here tonight. And in regards to the Truth and Reconciliation Commission's report and calls to action, we aimed to promote open public education, awareness, and action with the first Truth and Reconciliation Cafe in February, aimed at understanding the effects of residential schools by hearing the direct voices and lived experiences of residential school survivors and their families. It was a very powerful experience for everybody. And we collaborated with Nova Scotia Public Interest Research Group, who are generously providing funding for this, so we thank them. And we wanted to thank Lauren Amiot, I'm sure I pronounced that wrong, who is the event manager at the Dalhousie Student Union Building. Okay, finally, we would like to thank our speaker, Professor Naiomi, fortunate to have her here with us tonight, very generously sharing her time with us to speak about her work on the topic of Indigenous people in Canadian law. Professor Metallic hails from Listavoog, Mi'kmaq, the First Nation located in the Gaspe Coast of Quebec, known as the Gaspégoagui district of Mi'kmaq. She's fluent in both English and French, and is becoming fluent in Mi'kmaq, which she has been studying since 2018. Professor Metallic is a graduate of Dal, where she earned her BA and Bachelor of Law degrees, completed her licenses in law at the University of Ottawa, summa cum laude, before moving on to complete her master's in law with Osgoode Hall Law School. After 10 years of practice in Aboriginal law, she decided to make the move to academia and to continue her work through teaching, writing, and speaking about the issues facing Indigenous peoples in Canada and how the law can be a tool for reconciliation and improving the lives of Indigenous peoples. Since 2016, she's been an assistant professor at the Schulich School of Law at Dal, where she also holds the Chancellor's Chair in Aboriginal Law and Policy. And she's working on her PhD through the University of Alberta, and then she wrote stop.
That was enough.
That's enough. Just a quick thing. So I'd like to introduce Naiomi Metallic, and there will be a short break in between some of the presentations. And there's also, please feel free to ask questions as we go. We're going to try to do an official Q&A, but we're pretty loose. So,
thank you.
Professor Metallic.
Well, thank you very much for inviting me and having me. Wildasi Begisin Giskuk, which means I'm very happy to be with you today. I guess I could say Wildasi Begisin Walag, which means I'm happy to be with you tonight. Okay. I forgot your name, that's terrible.
Who, me? Oh, Mal.
Mal?
Yeah.
All right. As Mal was saying, feel free to ask questions since there's only a few of us. Yeah, closer?
No, the light is coming. If you're on right about there, then the light won't be.
Perfect. It's not like on my forehead. Great.
Yeah.
Thanks so much. I'm really happy to come and speak to you tonight about some of my expertise in the area of Aboriginal law. And just in case you've heard concept or the terminology Indigenous law and law, just to tell you the difference, because there is one. Aboriginal law is the stuff we're going to talk about tonight. It's a Canadian law as it relates to Indigenous people. So that could be statutory law, or particularly we're going to talk about the Indian Act and the Constitution Act. So Canadian laws as they relate to Indigenous peoples. But there's this whole emerging field around Indigenous law, which are the laws of the Indigenous peoples of Canada. In fact, we're kind of undergoing a revitalization movement right now. And anyway, if you're looking for a third subject to have some of your reconciliation talks about, I highly recommend perhaps looking at that, and I can recommend some speakers. I've been starting to teach some courses in that, and it's an important area to talk about as well, but very happy to talk on this subject. I've got two presentations which collectively are about 20 slides. So I think that'll give us certainly an hour, and I can talk, especially if I get questions. And so my two presentations. Oh.
I got it now.
Oh.
I got it now.
So the two presentations that I have, one is something I developed around 2015 or 2016, and I've updated it since. But it sort of looks at where we are in the current moment with respect to Indigenous peoples in Canada, and I'll talk to this slide in a minute. The idea of it is to, well, actually, I'll talk about it right now. These four eras that I have on the screen come from the Royal Commission Report on Aboriginal Peoples, which was a report produced in 1996. And it's a massive report and has amazing information in it, and I'll speak to some of that later. But the first volume of it explains it gives sort of a historical overview between Indigenous peoples and Canada, and in that sets out sort of four eras. Or tries to classify the relationship in four eras. The first one being the pre-contact worlds, where Indigenous peoples were here, lived on the land, had their own legal systems, had their own laws, cultures, traditions, languages. Then we get the first couple hundred years of contact, wherein we see significant treaty relationships being made between the different European powers that were coming here, or we have primarily, though, treaties with the British. And this is an important area to speak about as well. I've given talks, and there's some people who are just brilliant around this period of time. We often don't talk about it and sort of disregard it. But what's significant about it is that when, Britain and France were sort of warring for what they might say is control over North America, they were still at the same time also engaging with the Indigenous peoples here in such a way as to convey to them that their intention was not to dominate the Indigenous peoples, that the treaties that were signed at this time were not about cession of land, they were simply about coexistence and living together. Some of these treaties were signed as sort of allies, or as to be neutral, in particular Indigenous folks to be neutral in between the wars between Britain and France. This treaty period is, fascinating, and somebody can come and give a really good talk about what were some of the representations that were made to the Indigenous people at the time. There was this big conference in Niagara in 1764, a year after the signing of the Royal Proclamation, and at that conference, 20 different Indigenous nations from the Mississippi, westward, eastward, all over came, and the whole idea was that there was a representative of the British Crown who spoke to all of these representatives about what the Royal Proclamation meant. It wasn't intended to take Indigenous land. If Indigenous folks wanted to sell land, they could sell it to the Crown, but they would have to agree and consent to it. And also, the British Crown also represented that it wasn't their intent to take over or control the lives of peoples, and they use these wampum belts. I don't know if you've heard about wampum belts, but this 2-row wampum belt that sort of signifies almost two ships traveling on the same water together, but not touching each other, not interfering with each other. And that was used as a metaphor to explain both would coexist in this space, but not one or the other controlling each other. And there have been theorists and legal theorists for quite some time who have argued that that relationship could have had such a significant impact on how we interpret Canadian law today, and still can, but we've often ignored that history relationship. They refer to the possibility of it as treaty federalism, and there's some brilliant writing on this. That if we took a treaty federalism approach, we could have a very different relationship in Canada. And often when people today talk about nation to nation, it's along the lines of these sorts of discussions around treaty federalism. It's a fascinating topic, and that's about all I'm going to do on it for now. And then, because a lot of the focus has been on the third era that RCAP touches on in its report, it calls it the era of domination and assimilation, that happened sometime in the mid-18th century, and certainly by the time of Confederation in Canada, well into the 50s. And there are still elements of the era of domination that still remain with us. You were saying that you had a talk on residential schools not too long ago. And so, this is part of that era of domination and assimilation, as well as dispossession from traditional homelands, being placed on reserves, various provisions in the Indian Act that attempted to assimilate First Nations people, and so many other things. In this period as well, we had the Canadian government often trying to deny that it had responsibility with respect to some Indigenous people, including Inuit and Métis, and then in some ways with respect to Indians, or what we call First Nations now, exercising a lot of control in some ways, but a lot of neglect in others. So very dysfunctional relationship. Back more, if you ever want to do a really interesting exercise, the blanket exercise that is offered by Kairos is a great way to be introduced to some of that history. But what I'm going to focus on for the rest of my talk is this fourth period that the Royal Commission talked about, the era of renewal and renegotiation, which they timed at being somewhere around the 50s to the present. But that's a lot of time. That's 70 years now, and counting. And there's been some, definitely some improvements over the previous era, but still some things left to be desired. So when I created this presentation, it was to sort of hit the milestones, the big milestones in the last 70 years that have signaled some change for Indigenous people in this country, but then also to say but there's still problems, and here's problems that remain with respect to this milestone. So I'm going to run through that presentation because I think it's helpful to understand the current relationship between Indigenous peoples and the Crown. And then in the second part of my presentation, I have a slideshow. I'll mention this, but you may know that in this past summer, the Government of Canada passed legislation to implement the UN Declaration on the Rights of Indigenous Peoples. And I wrote a paper this summer and shared it. I think have I shared it with Jack? No, I've just shared the idea of it with you. I haven't actually let you see it yet. But I've been giving it a lot of thought, and think that although it'll be a lot of work, in fact, the work on implementing the UN Declaration could do a lot to address the problems that I'm going to speak to that I think are still with us. So in the second part, I will review how I think that can change some things in important ways. But for now, I'm going to get into explaining to you these different milestones. So they are amendments to the Indian Act that happened in 1951, the 1969 White Paper, not if you've heard of the White Paper. Okay, yeah, most people, good. The 1973 Calder decision, Section 35 of the Constitution Act, the 1992 Charlottetown Accord, and the RCAP report are going to be the 6 milestones that I primarily speak about. Okay, so let's get started. So To start with the amendments to the Indian Act, the Indian Act was, well, there was a predecessor legislation to it, and feel free to ask me any questions at any point. Predecessor legislation, even slightly before Confederation, some of the provinces or some of the colonies had somewhat similar legislation, but the first act was passed in 1867, 1868. It was called an Act for the Gradual Enfranchisement of Indians, which was all about assimilation. And then we get the actual Indian Act passed in 1876, and it's still in place today. It's undergone some amendments, but still in place today. And it's contained many of the policies. It creates reserves. It was, there was provisions in it that also provided for, various rules providing how the residential schools, allowing children to be taken to go to residential schools and other provisions. I'll speak to those. So, first of all, these amendments in 1951 were somewhat significant as representing, I think, a response to a bit of a change that happened after World War II. Of course, with the sort of global response, we get sort of the introduction of a bigger role for the UN, particularly with respect to human rights treaties and conventions and the UN Declaration on Human Rights. So we're seeing a greater concern for human rights across the board. And this starts to translate to Canada in terms of a recognition or concern for the well-being of First Nations people on reserve. It's sort of recognized at this point that Indigenous people, I think one more thing that I'll say is that post-World War II is when we get the sort of the real strong coming into being of the sort of Canada as the welfare state. By that I mean various programs and services, EI, the Canada Pension Plan, various other things coming into effect in the provinces, social assistance, child welfare, coming into effect and recognizing that there has to be certain supports that are provided by the state for people's well-being. And at that point, or around this time, it starts to get noticed that First Nations people on reserve are not being provided the same types of services that other people are coming to expect now under these new types of programs. And the policy of the government of Canada before World War II, when it came to First Nations people living on reserves, was quite dire in some respects. Well, we had the residential school system, but on reserves, Indigenous peoples had been displaced. They weren't really able to exercise their traditional hunting and fishing modes of subsistence. Were essentially sort of forced not to really leave the boundaries of the reserve by and large. Because of that, really their options in terms of how to make a livelihood were quite limited. There was no, pre-World War II, any sort of, what they had were Indian agents living on the reserve providing what were called sort of rations. And there's a great book, if you want to read it, by a fellow by the name of Hugh Shewell, and the title of it is Enough to Keep Them Alive. And that was the government's policy when it came to rations to Indians on reserve, was to just give them just enough to keep them alive, not to give them any more than that, and usually only to the most, the elderly and the most destitute, and anyone else should be, encouraged to pull themselves up by their own bootstrap, even though the sort of the impacts of colonialism were such that really there wasn't really many options. So the poverty in the communities was quite dire, and now with the advent of this social welfare system, it's starting to be noticed of the inequities that are existing in conditions on reserve. And so there's some pressure put on the federal government to look into this. So a committee is created who examines this, and kind of at the time, we sort of get a shift in assimilation sort of approaches. So prior to World War II, the attitude of the federal government when it came to residential schools is take the Indian out of the child, and essentially that being Indigenous was something that was backwards and that should just be that somebody should be rid of. in post-World War II, it was still a desire for Indigenous people to become part of the mainstream, but less so based on sort of the more explicit, you're a lesser human being, but rather, don't you want to be part of us? So it's sort of 6 to 1, half dozen of the other, but the idea being that the sort of best approach might be for Indigenous people to no longer be on reserve, to no longer have treaties, to no longer have the Indian Act, and simply just kind of be absorbed into the mainstream. So this thinking at the time was sort of couched in concepts of equality and citizenship. A concept of equality, however, that was, sort of the colorblind school of equality being that really formalistic, right? That, equality is treating everyone exactly the same, even if people have different needs and circumstances and deserve to be treated according to their needs and circumstances. So we get sort of an early version of equality. And the proposal is let's try to get the provinces to take over Indigenous services. Partly, I'm sure there was reasons of cost involved in this as well. So this was the recommendation of this committee. And they said, with all these services coming into effect, let's just see if they recommended that, the provinces take this over. And so Canada, Parliament, jumped on this when it was amending the Indian Act in 1951. And I'll explain that a bit more in a sec. I'll come to that. But in 1951, there was this massive overhaul of the Indian Act, and some of the earlier really egregious discriminatory pieces of policy that were in it were removed. Not all of them, but some of them. One being a ban on hiring lawyers. Did you know that from 1926 to 1951, there was a ban for Indigenous people to hire lawyers to represent them in land claims or any claims relating to the band. So that was, in place for about 30 years. There was also provisions that criminalized different spiritual practices. And there were a number of provisions that impacted on, they were called enfranchisement provisions, which, enfranchisement means the vote. And the reason why they call them this is because under the law in Canada at the time, if you were an Indian under the Indian Act, you were not a citizen. And so, and those who, considered this issue in government thought that, isn't that a bad thing that you're not a citizen? And so there were certain provisions that would remove your Indian status under the law and make you a Canadian citizen, some of them involuntarily. So there was a provision, for example, that if you became a doctor or a lawyer or got a university degree or joined the Holy Orders or traveled outside Canada for 5 years without the Department of Indian Affairs permission, those were all things that could automatically result in you losing your Indian status. Anyway, so some of those provisions were removed, some of the worst ones. But the changes in 1951, there was other things that weren't changed. The residential school provisions still remained in place. Various other provisions that impacted on the identity of Indigenous peoples still remained in place. Some of you may have heard this as sort of a long and storied history regarding Indigenous women, First Nations women who married non-Indigenous men. They would lose their Indian status. And this was the case right up until 1985, and there's still some ongoing, lingering effects of that. But these rules were kept in place. There's a long history, and there was a bunch of other sort of similar rules around status that impacted people's ability to be regarded as Indians under the Indian Act. And some would say, well, in the spirit of, well, maybe people wanted to become enfranchised and be a citizen, but then you lost your ability to actually live on the reserve and be surrounded by members of your family. So you would no longer be entitled to be among your people. So the MMIW report has called this sort of this, basically government banishment from your homelands. So some of these problematic rules around status remained up until 85, and I say even beyond. And I've done presentations just on those issues. But I'm just giving you a little smattering of this. The other thing that the 1951 amendments to the Indian Act did was introduce this Section 88 of the Indian Act, which, remember, going back to this idea, there was a proposal that, we should try to get Indians to become part of the provincial jurisdiction, so they would just kind of be absorbed into the provincial mainstream, and hopefully the provinces would provide services to them, and so the federal government wouldn't have to. Section 88 was inserted, and what it does, it says that all provincial laws of general application apply to Indians. And from what I've read, it seems that it was very much an attempt by Canada to say, hey, provinces, you should be the one providing education services and social services and child welfare services. They're your responsibility now. And so, as we see, this happened beforehand, but very much an illustration of the problem that I call the First Nations as jurisdictional hot potatoes, and both levels of government fighting with each other about who has the responsibility to provide services, sometimes very important essential services, to First Nations. And so this was sort of the beginning of that. And what happened when Canada inserted this is they did it unilaterally. They didn't speak to the provinces, and the provinces said, hell no, we're not going to provide these services, not unless you pay for it. We're not offering any of these services. So that has led to a long-standing sort of dispute, which I'll talk to a little bit more after. And I guess the last thing I'm going to say about the 1951 Indian Act is that this was the last time there was a major amendment to this act. Aside from little small changes, little amendments that have happened, this was the last time there was any sort of major overhaul. So most of the pieces that are in the Indian Act today haven't really changed since 1951. And there's a bunch of massive areas or gaps in it. Sometimes people often think that you might have heard people say, oh, the Indian Act is cradle to grave legislation. In some ways that's true, because there's actually provisions about wills and estates for Indians on reserve, and so it catches that, and there's provisions about estates of minors. But at the same time, going back to this idea of all these services that were sort of coming of age in this era around education, essential services, child welfare, housing, policing, emergency services. So that's milestone number one, and it'll get touched on again in a sec. So my second milestone is the white paper policy, and I saw that most of you were familiar with it, and it sort of continued some of the sort of assimilation in the guise of citizenship and equality sort of discussion. So we get this introduced by Pierre Trudeau and Jean Chrétien in '69, and under the sort of mantle of formal equality was the proposal, the same idea I mentioned earlier, that reserves are keeping Indigenous people back, treaties are keeping them back, not the history of colonialism, no, not that. The Indian Act, that's what was keeping them back. So, or some sort of special recognition in law is what's keeping them back, not their treatment by governments. So this was the proposal, and gradually reserves and the Indian Act and treaties would all be phased out. This was the thinking. The reaction to it, as many of you probably know, was perhaps quite surprising. It ought to have been to the, or should not have been to the federal government. But Indigenous people reacted with significant amount of resistance. And Indigenous people have always in various ways resisted attempts at colonization. What occurred in relation to the white paper was a sort of a national resistance movement that had yet to be sort of paralleled in terms of we had regional groups forming in response. We had a national group. We had the creation of the Indian National Brotherhood. And so various resistance bodies are created at this time, and very strongly pushing back against this policy. And so I think by 70 or 71, the federal government withdraws the white paper policy and commits to an approach that would be more informed by community in terms of how it would be moving forward. So the white paper itself is not a positive thing. The reaction to it was, and we're going to see that various things kind of resulted from the government pulling back on the policy and the advocacy that Indigenous people started to undertake once they sort of became colonized as a result of the white paper. But there's all kinds of things about the white paper policy that are sort of worth mentioning here. The remnants of it are still with us in some respects, very much with respect to the area of program delivery and services, essential services to Indigenous people. And this is not a super sexy area for a lot of people. They're not really aware of it so much. They might be more because they've heard conversations around child welfare and heard of Cindy Blackstock. Some of the work I've done has also touched on this area. But essentially what happened, because Canada and the provinces were sort of fighting over, no, you should provide them services, no, you should. The provinces would only provide services if they were fully reimbursed, and they only agreed to with respect to child welfare services because they were getting pressure from social workers. But beyond that, they didn't want anything to do with providing basic essential services to First Nations people on reserve. So what happened is that Canada begrudgingly decided it would start to offer services and programming similar to what was being provided in the provinces. Instead of amending the Indian Act or passing legislation in order to do this, instead it got Treasury Board authority to fund similar services to what's provided in the provinces, so at the same levels as the provinces. However, there's a lot of evidence now today that suggests that that's not what happened. The federal government, although it nominally says that it's providing a similar level of services to the provinces in the child welfare on reserve. So they just took the provincial policy and sort of plopped it on reserve, but without sort of looking at it to see whether it would be appropriate, whether it would meet the needs of First Nations people. So there's significant issues, and if you're interested in reading a lot more about this, because I could go on about this at length, there are far more problems with this system than just what I've mentioned. Eventually, the programs get delivered by First Nations. The government agrees to allow First Nations to do this. So this is my second point here. There's, after the white paper, more emphasis on community-driven programming. And but this is, and First Nations at this time are starting to ask for self-government. What they get from the government, however, is not self-government, but something called self-administration. Where they're given the money to administer the programs funded by Canada, which it says is based on the provincial sort of standards or and rates of services, but often under funding agreements that are very restrictive, and there's no negotiation often with some of these agreements, these funding agreements, particularly with some services. And so there's little First Nations say or control, or often there hasn't been, and we're going to see that there's been problems with respect to funding of services that have just sort of exacerbated those problems. And so, yeah, this has created a really major issue, which we're starting to unravel, but this is sort of one that tends to go unseen, right? Even when we're talking about TRC and other things, just the massive underfunding and just the dysfunctional delivery of services on reserve, I think, has been massively responsible for the exacerbation of poverty. Right? And often when people look on reserves and they see poverty, they think, oh, it's just intergenerational effects. It's just intergenerational effects of colonialism in residential schools. And I'm like, no, it's actually because of policies that are in place right now still that are keeping this poverty in place. And this is facilitated by the fact that there's been little legislation, right? A lot of this is done under Treasury Board authorities and funding and policies, which, gives the government a significant amount of discretion, which when the government's doing good things and doing the right things, that's good. But you can also have a government that may come into power that's less inclined to want to spend a lot of money on First Nations. And there's a lot of room to maneuver there. And it's difficult to hold government accountable. I had a case around social assistance on reserve from 2011 to 2015. And because there was no legislation, at one point the court even said to us, this was the Harper government, of course, they wanted to slash welfare rates on reserves to a point where it was very clear even to the departmental employees that this was going to have severe repercussions on very poor, very marginalized people. And and the court even said, well, there's no legislation. I don't even know if I'm able to review this. And because it's about money, we got a little bit of relief in that case. But the point is that because there is no legislation, it really makes accountability very, very challenging in this area. So in some ways, the current approach to some service delivery on reserve still emulates aspects of the white paper policy because they're not community driven really. The communities don't have a significant say over it, and the underfunding and underservicing is just, entrenching those problems. So there's that. The next big milestone that I'm going to touch on is the 1973 Calder decision. So we're switching gears a little bit. We're going to talk about Aboriginal rights instead of Aboriginal services for a sec. So post-white paper, again, I had mentioned there was significant Indigenous advocacy at a national level. So you see First Nations people starting to go to the courts to have their rights recognized, their inherent rights to land, to exercise in traditional subsistence activities, to have their self-governance recognized, because a lot of that has not been recognized in Canada. Actually, and I won't speak about it too long, but in the US, in fact, they have a very different history, and they've recognized inherent rights to self-government for quite a long time. But I can speak to that in a question period. So we get Indigenous people going to court, and we get a decision from the Supreme Court of Canada in 1973, where it was the Nisga'a in British Columbia seeking a declaration from the court that their Indigenous or Aboriginal title, their claims to property in the land stemming back from before contact, continued to exist in law. Which to this point had really not been recognized very much, or at all, really, by very few court cases, none from the Supreme Court. And what we get is this interesting decision where you get 7 judges, 6 of whom agree that Aboriginal title exists. But they have, or it existed, became part of the common law of Canada because of the pre-existence of Indigenous people before the arrival of Europeans. The fact that Europeans then came did not, 3 of them said that 3 of the 6 judges who found that Aboriginal title existed in common law said, oh, well, no, in British Columbia it's been extinguished. The fact of the colony of British Columbia and then becoming a province, exercising legal jurisdiction, essentially negated those rights and they disappeared. Then there was 3 other judges who said it's possible for that to happen, but it didn't happen in this case, and in fact it should be a high threshold. And these judges were looking at case law primarily from the United States of North America, that Indigenous people's rights existed at common law, and in fact the British recognized this in things like the Royal Proclamation and various other treaties that were signed early on in the relationship. And in the US, some of these cases, in fact, there was 3 sets of cases that came out from 1820 to 1832. And in this first case, the court said, yeah, their common law rights continue, although they are affected a little bit by the fact of discovery by Europeans. But they said what it does is that it means that the Indigenous people can only sell their land to the British Crown. They can't sell it to private parties. And then in some later cases by the U.S. Supreme Court, sort of along these lines, they said, but that doesn't go much further. The discovery by Europeans doesn't have a significant impact on Indigenous people, and that's where we get this case law developing in the U.S. that recognize the inherent jurisdiction and inherent self-government power of tribes. And they were called in one of the decisions domestic dependent sovereigns. That they were somehow still within the United States, but possessed inherent sovereignty, and this is why in the U.S., and there's a few more reasons for this, but in the U.S., most of the tribes have their own court systems, their legal systems are recognized, so a very different case law. But our Supreme Court went and drew on some of that case law, not all of it, But they drew on the part that said, yep, Indigenous peoples' rights continue after the arrival of Europeans because they existed pre-contact. But they were mostly talking about it as property rights, not so much in the self-government inherent rights part of it, which we'll see is a problem. But our Supreme Court, 3 of those judges said, yep, these rights exist, and if we want to say that they've been extinguished somehow by the European powers that have been here, it's got to be super clear. It's got to be like legislation that says we are, eliminating, extinguishing Indigenous rights. They said it has to be at that level of clarity, and they said it didn't happen in British Columbia like that. And so we get this decision 3-3 about whether that Aboriginal title exists. Some said it was extinguished, 3 said it wasn't, and then we get the 7th judge who was just like, I'm going to decide this on totally procedural grounds and not weigh in. And so that's where we were left with. But it was a real watershed decision because it opened the door in Canada for the recognition of Aboriginal rights, inherent rights. So this then becomes a catalyst for many things that we see happening in the 80s. In some ways, it becomes a catalyst for Section 35 of the Constitution Act, and I don't know if you're all familiar with it, but we repatriate the Constitution in 1982, and we get the Charter of Rights and Freedoms that's put in at the time. Some Indigenous folks at first were, really concerned about repatriation because they thought that Canada would just say, okay, we're cutting our ties with Britain, and we're also cutting our ties with all those treaties that Britain signed with the First Nations people. So a bunch of First Nations people went to England and went before the House of Lords and actually said, you have to say that Canada can't secede, and secede from and kind of cut its ties in many ways from Britain. The House of Lords said no, but they said, we hear you. We hear that you're concerned about your treaties, but as a successor of Great Britain, Canada would still be bound by all the treaties that we signed and would continue to have obligations. So the court there sort of set that out, and that somewhat paved the way for then, after that decision, pressure was put on the government to include a provision in the Constitution Act. It was repatriating the Constitution to recognize Aboriginal and treaty rights. And so we get this section 35 in the Constitution that says the Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. That's all it says. And then there's a second subsection that says Aboriginal peoples means Indian, Inuit, and Métis. There's a few others, but those are really kind of the 2 main parts of that. So that gets inserted into the Constitution. I'll come back to that. Getting back to another impact of the Calder decision is that after the Supreme Court recognized Aboriginal title, even though it was still kind of up in the air a little bit, Canada decided to reverse its longstanding policy of not negotiating any claims with respect to land. I said earlier, for 30 years, they even banned lawyers from representing Indigenous groups. After one of the Treaty 11 of the numbered treaties signed in 1923, I think it was, 1923 or 1926, Canada said, no more treaties. We're not signing any more treaties. And when there were claims about, treaties that had to be that created rights to reserve land or reserve land that had been encroached by other people, and so sort of a different type of land claims, what we call specific land claims. And the second are called comprehensive land claims. Those are claims to large pieces of territory. The claim that the Nisga'a had when they went to court in Calder is called a comprehensive land claim. And there's various groups in Canada that have comprehensive claims, to their traditional territory. So it was only at this point that Canada actually introduced policies to say, okay, we'll negotiate these. Only in 1973. As a result of them, there has been some what we call comprehensive claims, so large treaties recognizing Aboriginal claims to large swaths of territories, but also in these treaties exchanging, in some cases extinguishing the right to claim those large pieces of land for certainty over other parcels of land. Sometimes these agreements also have things like cash settlements with respect to the land, co-management agreements. this is another area we could spend a lot of time looking at. But the point is that we get these, some modern treaties is another word that's given to these. There's been a number of modern treaties in the north, so involving in the Yukon and Northwest Territories. The creation of Nunavut was the product of a land claim negotiation with the Inuit. Instead of going with self-government, they decided to create a public government. So anyway, the point is that there's been some of these agreements signed in since 1973, and the Calder decision had a massive impact on that. And there are still various negotiation tables happening across the country. But there's also some significant problems here as well. One being, as I said, we kind of pulled our approach to Aboriginal inherent rights from US cases from the 1820s, what are called the Marshall Trilogy. And it's good on the one hand because it recognizes the inherent right, inherent rights that predate the arrival of Europeans. And in Canada, it sort of changed the narrative because for a long time there was a decision from the Privy Council that said that any rights that Indians had was because Britain gave them those rights. Talking about the Royal Proclamation and some other things. But a problem with this is that it still deeply relies on the doctrine of discovery, right? It assumes that somehow, simply by arriving on these shores, that Europeans magically gain power, to claim all the land and all the power over all the people on these lands, which, even at the time in the 17th century, around that time, was disputed as either a valid moral or legal claim, and as the centuries have gone by, very much disputed because these are based on sort of ideas that are based in racial hierarchy. The doctrine of discovery came along to supplement the doctrine of terra nullius that existed in international law. The doctrine of terra nullius says that a European powers going across the globe, discovering new places, if it comes upon a new place and there's nobody there, they're entitled to claim all the land. Just like that. But what happens when there's people there? Well, that's where the doctrine of discovery came along. Doctrine of discovery said, but if there's people there, okay, but if they're not Christian, and if they're not as civilized as we are, then it's justified to claim all their land. And so the doctrine of discovery is a prominent feature in some of these US cases, although in the US they sort of attenuated a little bit by recognizing more jurisdiction to the Indigenous folks around self-government. But in Canada, we sort of picked and choose, and we only kind of took the part that said that doctrine of discovery means that the Crown is absolute. And so we still have this underlying so much of our Canadian Aboriginal rights jurisprudence. And I'll speak to that a little bit more after that. Beyond that, the policies that Canada has developed around negotiating land claims, there's been a lot of problems with them. With respect to either the creation of reserves or that were supposed to be created under treaty, as well as various reserves over time that may have been improperly stolen, taken, or encroached upon. There's a massive backlog of these. Canada has created a process, but it's been criticized heavily for not being fast enough, not being effective enough, and needs an overhaul. Even though it's kind of had a couple of overhauls in the last 20 years or so, it's still quite problematic. And then these sort of larger land claim negotiations, well, a problem with them is that they're taking decades upon decades to be negotiated, and millions of dollars, just millions and millions of dollars. They're being negotiated sort of on a piecemeal basis. So some of my writing has been looking at just how time consuming this is. And this is, it takes sometimes 30 years. The Nisga'a, it took them 30 years to negotiate their land claim. And so, these agreements are extremely slow and they're not leading to significant reconciliation in any sort of fast way. Also, depending on the government in power, the timing of these can be, it's all based on political will. None of this is legislated. Again, another example where there is no legislation. The government has these policies. And so a lot of this is within the government's discretion about whether it wants to negotiate, how fast it wants to negotiate, how much it wants to pay. And so the First Nations are often in this very significant power imbalance where the government calls the shots on these processes, which are supposed to lead to reconciliation, but often the government holds a significant upper hand. So that's the Calder decision and some of its impacts. And then we get Section 35, and I'll just put them all there up now. I've already spoke to some of that. So I mentioned Section 35. It recognizes Aboriginal and treaty rights. And it has been interpreted by the Supreme Court of Canada about 30 to 40 times over the past 40 years almost. And it's mostly been, it's mostly fallen to the courts to interpret it. The Supreme Court has given us various cases, and they have gone back to, they went back to Calder and they said, yeah, the judges who relied on the US legislation had it right. So our cases are sort of based in still the Doctrine of Discovery, but they do say that still these rights existed prior to the arrival of Europeans. They weren't entirely extinguished just by the coming of Europeans. And Section 35 puts some limits on what governments can do in relation to Aboriginal rights. So we get a series of cases from the Supreme Court that recognizes rights to often to engage in hunting and fishing and other gathering practices for the purposes of food, social or ceremonial purposes. We get some cases, we're all familiar with the Marshall decision, that recognize sometimes some economic rights in Marshall with respect to moderate livelihood. In a decision called Delgamook in 1997, we get recognition of Aboriginal title. And the government, and the court, defines these as being broad rights to control land, if it's proven, but there are some internal limitations on them. I won't get into all the details of that. There was a case from 2014 called Chilcotin, where a group from British Columbia was able to prove Aboriginal title to 6,000 hectares of land within the interior of British Columbia. The court cases sort of recognize that there's a significant sort of control component that comes with Aboriginal title. The courts also recognize the duty to consult that the government has if it's going to make decisions that impact on Aboriginal rights, even if the right hasn't been proven in court yet or had been the subject of an agreement with the federal government, that there's still a duty to consult. So those have been significant developments. So don't want to diminish that too much, but there are lots of critiques that have come with the Section 35 jurisprudence. One is just the level of proof. It's not that, the presumption is that Aboriginal people have these rights to hunt and fish and rights to their traditional land, and that it's on the government to disprove that they don't or somehow gave it up or somehow can't exercise it. It's the opposite. Indigenous people have to go to court, they have to prove, and the test is quite rigorous. When I teach it to my students in constitutional law, they're usually quite floored by it. But for example, if I want to prove that I have a right to hunt, or any other activity, even the right to self-government sort of has to be proven with respect to this test. But essentially, you have to show that your ancestors engaged in a practice prior to contact, so prior to the arrival of Europeans, and that practice was integral to the distinctive culture of your group. So not just incidental or not just something they did, you have to show that it was integral to who you were as a people in order to get recognition of that right. And it's often non-Indigenous judges determining what is integral to a certain Indigenous culture. So that's just an element of having to prove that test. It also has to show that there's continuity between the present exercise of the right going all the way back to pre-contact. There's a whole bunch of other aspects to the test. And it's quite challenging on a lot. And sometimes, pre-contact is, for Mi'kmaq, for example, the 15th century or thereabouts. So quite a big burden of proof. But for self-government, the court was really hesitant to touch self-government. They said, we're not even going to decide specifically whether Section 35 includes self-government. But if it does, you got to use the same test. You got to show that it was a practice done pre-contact that was integral and distinctive to that specific society, and it has to be very narrowly circumscribed. One scholar named John Burroughs has written about how absurd this test is and how it really freezes Indigenous communities. But he said, let's say there was a First Nation who wanted to address gendered violence in the community, and they wanted to pass a law and rely on the inherent right to self-government to address gendered violence. They would have to prove that violence in their community was so expansive. Violence against women was just something that happened with such a degree that it made it something that made it distinctive to the culture, which is absurd. He said, why would a community go to court to embarrass itself in that way? But they would have to prove that it was that violence against women was integral to the culture in order then to be able to regulate violence against women today. And it just makes no sense. But that's sort of the law that we are stuck with currently, which really doesn't provide any real modicum of control to Indigenous people over their lives. So this has been a really huge issue. And with all of this case law as well, it's all into the courts, so Indigenous people have to go to court. The burden of proof falls on them. And so all of these cases come with a significant high cost of litigation. I've litigated for 10 years or so, and I mean, cases aren't cheap, and so, if you wonder why there isn't a lot of case law, I mean, there is some case law, but it is, significantly challenging in bringing these matters to court. So that's Section 35, and the TRC report actually said that Section 35 is not achieving reconciliation. They said it's not going to achieve reconciliation until such time, so I'll just read it. Reconciliation vision that lies behind Section 35 should not be seen as a means to subjugate Aboriginal people to an absolute sovereign crown, but as a means to establish the kind of relationship that should have been flourishing since Confederation, as was envisioned in the Royal Proclamation and the post-Confederation treaties. Very much sort of that treaty federalism approach I touched on a bit earlier. In Canada, law must cease to be a tool for dispossession and dismantling of Aboriginal societies. But the main culprit that the TRC picked up on was the doctrines of terra nullius and Doctrine of Discovery, which continue to underlie Canadian law, particularly our Section 35 law. As I said before, it's embedded in Calder, and the Supreme Court has continued to embed it in its rulings. And it's not just a matter of, principle. It's actually in practice influencing the development of the law. It impacts the fact that the Crown can significantly justify the infringement of Aboriginal rights. It impacts the fact that there is no veto on consultation. It is a big reason why the onus of proof is on the First Nations people and not the Crown to prove that they don't have these rights. So various scholars have written about that, and to say that this is sort of a significant problem is Section 35 and how it's been interpreted by the courts over the years. So another area, I think it was my second to last milestone, I'm getting there, is the Charlottetown Accord. So after the Section 35 and the repatriation of the Constitution, some of you who can remember some of the constitutional stuff that happened in the decade after, there was the Meech Lake Accord, which included nothing about Indigenous peoples, and then so we get the filibuster from Elijah Harper, and then in the next round of constitutional talks through the Charlottetown Accord, there was a far more, because of the failure of Meech Lake and how Indigenous people really sort of pushed its failure, there was a greater recognition of the need to involve Indigenous people in the further constitutional talks. Let me back up for a sec. In 1982, when Section 35 was added to the Constitution, Indigenous people were asking for a lot more. Problem with the provision is it's just so broadly worded. Aboriginal and treaty rights are hereby recognized and affirmed. What does that mean? So Indigenous people at the time were asking for far more things to be recognized, like the inherent right to self-government and various other procedures and rights set out much more clearly, but first and foremost, the right to self-government. And they were told, well, we got this in here. We're going to have some more constitutional conferences, and they even put in some provisions in the Constitution to say when there is another constitutional conference, we're going to negotiate, or we're going to talk with you a little bit. But in any event, in 1992, when Charlottetown was put to a national referendum for a variety of reasons. And unfortunately, although it would have amended Section 35 to explicitly recognize the inherent right to self-government, it failed. So fairly disappointing period of time. What we get after this is the Liberals running shortly after the referendum on a campaign to do something to recognize the inherent right of self-government in Canada. And so after the election, the Liberals then pass what's called the Inherent Rights Policy on Self-Government, passed in 1995. And what it does is it's a policy that sets out a process by which if First Nations want to, they can initiate with the Government of Canada negotiations for recognition of certain rights to self-government. You can still find this policy online. There's sort of 3 different categories of areas that the government said it was comfortable to negotiate on, 22 categories in one, that was things that were sort of regarded as internal to the Indigenous group. Then there was sort of a mid-category that they said we might be able to marriage and divorce and some other sort of provisions. Anyway, it's kind of a strange list, but they said there's sort of a middle ground that we might be willing to negotiate some type of agreement on. And then they said there's this 3rd category, which is completely off limits, like national defense, but also things like copyright. It was, again, sort of a weird list, or copyright and other intellectual property stuff. And Indigenous people do have some interest in that. But anyway, this was this policy where the government said we'd be willing to negotiate on these areas, and they set out all the conditions upon which a group had to satisfy in order to come to the table and to negotiate, and the Canadian Charter of Rights and Freedoms would have to apply to the exercise of self-government, and all of these things. So, I mean, on the one hand, that's good. It recognized that. It provided a framework for the negotiation. 22 self-government agreements have been negotiated since 1995, probably 1 or 2 more since. Most of them negotiated in partnership or in tandem with these modern land claims. So earlier I mentioned the comprehensive claims process. So some of those get negotiated together. You get negotiations over land, and then at the same time over self-government. But some of these are more self-standing ones. One of the earliest ones was here in Nova Scotia, if you didn't know that, but only on a specific area. The Mi'kmaq of Nova Scotia signed it's called a sectoral self-government agreement over education on reserve back in 1999. So, a good thing, it has recognized some self-government, but the challenges with it is that it doesn't allow for the exercise of Indigenous people, the unilateral exercise of self-government. An Indigenous group cannot just say, we're going to declare self-government over this area or that area. They have to negotiate with the government, often for a very long period of time. And the process, like the other negotiation processes I mentioned earlier, are slow they're only benefiting those who are able to kind of stick at the table and stick it out. And again, this is an area where there is no law. It's a policy of the federal government. And again, that it gives them a lot of the upper hand and a lot of discretion. And so what we are seeing as a result of that is not a lot of First Nations exercising self-government. And for a lot of Indigenous groups in Canada, that's the most important right that they want to be able to exercise. I mean, of course, there's big issues on land as well and sharing of resources, and I think they're all intertwined. But the ability to control their destinies after, about a century and a half of having almost everything determined for them and decided for them and controlled is a really important right. And I think because of that, and because of the stuff that I talked about earlier, how services on reserve work, I think the two are certainly related, and that the quality of life in communities has not really improved. So this is a well-being chart that the Government of Canada produced in 2015 or 16. The blue line shows, it's a community well-being index score. And it measures certain things like education level and I think housing. Anyway, it measures certain services that people get or certain criteria to determine what their well-being score is. People have criticized this as not being, categorizing the right things about what measure as of well-being. It's very much focused on material things. But leaving that aside, you'll see that this well-being score, so the blue line is non-Indigenous Canadians, the red line are the Inuit community, and the gold line are First Nations. And it just tracks a deep 20-point gap over, from 1981 to 2011, so a 30-year period. And I think my writing has talked about how it's part and parcel, part of the delivery of services, and how various funding and services on reserve are deeply underfunded, and so it's just exacerbating poverty. At the same time, Indigenous people really lack the ability to exercise self-government. They have to be able to negotiate this with the federal government. These take a really long time, and even in areas of education can take 20, 30 years. The Anishinaabe of Northern Ontario recently signed a self-government agreement that was 30 years in the making, just over education on their reserves. So the processes that currently exist to try to attempt to address reconciliation are very, very slow and are not, the status quo is not working, I guess is essentially sort of the lasting sort of point that I would make, that where we are currently at. Quickly just talk about the Royal Commission report on Aboriginal peoples. It was meant, it came after the Oka crisis. It was an amazing group of Indigenous Canadians and non-Indigenous Canadians coming together, writing a report, 5 volumes long, informed by all kinds of fabulous research about, identifying solutions, identifying the problems, identifying solutions, and setting these out in really thoughtful ways. Unfortunately, most of it just sort of gathered dust on shelves. There's some impacts that it had. The RCAP report brought the residential school issue to light in a way that had not been, and then that led to the class action suits, which also then led to the TRC. So there's these lines of connection. So that's good. And in some court decisions, the Royal Commission report was relied on by government or by people making arguments in court for certain recognition of sort of gave really important social context on issues Indigenous people face, and they were used by the courts to inform some decisions. So that was a good thing. On the other hand, though, there was very little receptivity by the Chrétien government in '96 and onwards to really implement the report. And there were some amazing parts of it. If you're a big self-government person, read Volume 2, which talked about land and self-government and set out a real, amazing blueprint about how to get to real reconciliation on this, the types of legislation we would need, the types of cooperation from the federal government and the provinces. Really, really, really well thought out. But little receptivity on that. And so most of it just got shelved. So people would make the government's response was something called gathering strength, and it then after a while simply became dubbed gathering dust. And then we get to these austerity measures brought in by Paul Martin in 1996 as part of Chrétien's government, where we were facing the national deficit, and all the federal departments were expected to cut back for a couple years. And Indian Affairs, and there's a great little article on this if you want to read more about it, by a guy named Scott Serson, who was the department deputy at the time. But the department said, look, we can't cut, we're already underfunded. And they said, well, don't cut, but here's what we're going to do. We're going to cap it. No growth in the department over 2% for 2 years. That was supposed to be the thing. But what happened was, even after the austerity, the planned time period for the austerity measures ended, the cap was still kept in place until 2016. While other departments' growth was able to, expand. And I mean, especially with a population that, has a very high birth rate and significant needs, this, as some people have argued, is what really killed the momentum behind RCAP, because it really signaled the government's lack of willingness to be able to adequately fund services and needs of Indigenous folks. So that sort of is what happened to the Royal Commission report. And really, for the next 20 years or so, under Stephen Harper's government, during his years in government, there hadn't been a lot of movement. We do get the TRC report in 2015, which is significant, and I can speak to what I think about it. I think very highly of it and what it's been able to do. It also led to the Missing and Murdered Indigenous Women's Inquiry. And in the last 5 years or so with the Liberal government, we get things like an introduction of a Crown Principles on Reconciliation, and this government trying to do some more things. Is it perfect? Not by any stretch. But there are some aspects of this where this particular government has been more active in legislating on certain things respecting Indigenous people, sometimes because it was sort of forced to by the TRC or some court decisions. But for example, in 2019, an Indigenous Languages Act was passed, as was an act with respect to First Nations, Inuit, and Métis child and family services. And this act is actually really significant and sort of a turning point. It's the first piece of legislation to recognize the inherent right to self-government as a freestanding right with respect to this area of Indigenous child welfare. So there's a few important changes that are happening, but boy, they've been slow coming. And so I think what I'll do, what are we now, time-wise? 8:30. I think I will give that break or pause that you were desiring, and maybe we can have some questions, and I can talk a little bit about UNDRIP after that.
Awesome. Just wanted to make a quick thing. Do you want to take, if anybody needs to go to the washroom, it's actually right to the left of the hallway. If you want to do that now. But after you
What do you, let me throw it back at you. What do you think's behind it?
Lack of goodwill.
Yep. That's a big part of it. Still that sort of, the sort of mentalities that underlie the Doctrine of Discovery and assimilation is too, that, these beliefs that the Crown has absolute control and power, and also on some of this underfunding stuff. I do a lot of work with Cindy Blackstock, who is this amazing advocate for First Nations children, and she was instrumental in bringing a huge human rights complaint that was successful in 2016. But one of the things she said, sort of going to your point, Megan's mom, whose name I forgot, was that, lack of will, but, she says it as, with respect to First Nations children, discrimination is when the government doesn't think you're worth the money. Right, and so that's I think that's a big part of it too. Yeah, that a lot of this, and it's uncomfortable conversations about sharing of land and resources and things like that, and a lot of people are not very comfortable with having those conversations.
Yeah, it just seems like there's in government, it's slow anyway, but when it comes to Indigenous affairs, it's glacially slow, and there's a lot of heel dragging and avoidance, and I think you mentioned with some really good report that was done, it's just not received.
Yeah, the Royal Commission report. Yeah, it was phenomenal in terms of its breadth and in the sort of, I have people who often say, oh, but these issues are so complex, I'm sure I can't even get my mind around. I'm like, people have thought about this, right? Like, really, really smart people have been, poring over some of these questions and have solutions and ways, but sometimes there's just either a lack of knowledge about some of these options, or just a lack of will to really learn about them too. But that's a huge issue.
So you got sort of a general political will to move things forward. It's like you were just saying, we got all the good stuff. This is good. Do the thing. Just do the thing.
Yeah, that's really hard. And I don't know if the 5-year election cycle is also part of it. You can do a little bit of things, but sometimes the really big things. And also the provinces are highly unwilling to, and the provinces and the federal government have often used each other to sort of evade responsibilities in many ways, and they'll do that around land issues. The feds will say, well, there's not too much we can do without the provinces, so if the provinces don't come to the table, sorry. And a lot of the provinces don't want to come to the table. I think the government of Canada could force them because it has the jurisdiction over Indians and lands reserved for Indians in the Constitution Act. So it does have some constitutional power, but it often doesn't want to exercise it. Is that going back to political will again? Yeah. Did I hear Jack had a question or a thought or a comment? No?
The Doctrine of Discovery, New Brunswick,
Mm-hmm.
it lingers.
Mm-hmm.
It's sort of embedded
Absolutely.
in the consciousness mind.
It's totally embedded in the consciousness. God, when I went to law school in 2005, we didn't even talk about it. Like, even when we talked about Section 35, the people just thought, isn't Section 35 good? But not talking about, like, the fact that it's still underlined by these concepts that just assume absolute crown sovereignty, and that it's still just so deeply embedded in consciousness. I do think, so this is my second part of the presentation, will be on how I think UNDRIP helps us fight that and sort of bring it into the consciousness and a discussion that, we have to sort of say, well, how is it that Canada got control over all the lands and all the power? How again? And how was that legal? And how was that moral? So, yeah, I think, so I can jump into that unless there's some questions that folks otherwise have.
Would you like to take a break for?
I'm good to go, so I can talk for a long time. You might have guessed.
Excuse me for 1 second, just because I got bad circulation. I occasionally have to walk it off.
Sure.
So I'm not trying to be rude at all.
Yeah, okay. What we can do is find Jack on your computer the next slide deck.
Oh, yes.
Yeah. So I bet if I do this, is it right on the slide deck? So this one's shorter, and I swear, and you've already gotten my precursor, right? So I won't take as much time. But this was all a little, disheartening in some respects. This one, I swear I'll be a little bit more hopeful. I think. I mean, still a lot of hard work, but for people in the room who are, wanting to be good allies, I think there's some good stuff here for all of us to be excited about. So the paper I wrote this summer was about how I think that the UN the UN Declaration, I think most people in the room probably have some sense of it, right? It was passed by the UN General Assembly in 2006. And it's a document that was, I think, the first UN document that was ever drafted by the people from whom it was about as a manifestation of the right to self-determination. Same rights are found in these documents that Canada has already ratified and through conventions. But they specifically say this applies to Indigenous people because people weren't believing that, again, for lack of will, lack of goodwill, those sorts of issues. So it gets ratified by the UN or passed. At the time, Canada and 3 other states, colonial states, the US, Australia, New Zealand, are holdouts. But in Canada, within 4 years, all of the governments had changed their tune. They had endorsed the agreement in some way, shape, or form. In Canada, the Conservative government eventually did a little bit with some reservations on some key rights, including free, prior, and informed consent and self-determination or self-government. But when the Trudeau government came into power, they endorsed it without any reservations, and they also committed to implementing the TRC calls to action. And one of the big things at TRC was to recommend the implementation of the UN Declaration as the framework for reconciliation. They thought that it had all that was, significantly needed to help really advance reconciliation. So eventually, there's a big long story. There was a couple of attempts to pass legislation to implement the UN Declaration. So we get this legislation in 2020, and I thought it was 2021. I think I'm wrong with that. I think it was just this past summer. So please ignore my date there. We get this legislation what it does is basically it does a few things. It commits Canada to a plan to implement the UN Declaration. And some people think, well, that's not really doing a lot. Canada's got 2 years to set forward a robust plan about how it's going to look at its existing laws, create new laws to be in conformity with the UN Declaration, as well as its policies and other things. So some people think, well, that's not really a huge deal, but those who have been working on this area think it is, right? Getting the government to commit to a legislation that will then lead to a lot more work. And I tend to agree with them. And oh yeah, the other thing the legislation does is that it recognizes that the UN Declaration has effect in Canadian law. There's a provision that just says that. And actually that's not creating anything really new because the UN Declaration already had application in Canadian law, and I won't get too big into the details, but in fact, all fundamental international human rights law that Canada has endorsed or ratified is supposed to impact Canadian law and the interpretation of our domestic laws. But surprisingly, that's not really known by a lot of people, including judges and lawyers, and that tends to be a problem. And so this legislation will also help address the fact that for the last 5 years or so, a lot of judges and lawyers have erroneously said, oh no, it's just aspirational, it doesn't apply. It already does apply to, and in fact there have been some cases where the courts have said, yeah, it applies, and I can use it in interpreting existing Canadian law. I won one of those cases, so I can tell you for a fact that that's true. Okay, so my paper was about, now that I've given you that big long preamble, how I think that this bill and just implementing the UN Declaration can help us move in a much better direction. So what are the problems with Section 35? We already said it, right? Lack of political will by governments to proactively implement. Particularly around Section 35, that's been a huge problem. What we've seen in the last 30 years, and I think is part of the issue too, is that we've gotten 30, 40 court decisions, but largely governments in Canada have not seen themselves as having any proactive requirement or obligation to actually implement Aboriginal rights. So we always had to take them to court to get the court to say you weren't supposed to do that. And we have gotten some agreements and treaties over time, but largely I would say that, when it comes to Section 35 Aboriginal rights and treaty rights, a lot of it's been largely left to the courts, and that's been challenging. And there's been a number of things that have called on the government to actually pass legislation to implement Aboriginal and treaty rights and self-government. So I've got the name of them. There's even some court cases where the Supreme Court said, government of Canada or province, you could legislate in this area. We're just setting the minimum standards on Section 35. If you wanted to, you could go beyond this. But most governments have not really touched that. And I guess the other problem with Section 35, trying to unpack that a bit more, is leaving it all to the courts is not going to result in massive transformational change for a few different reasons. One, judges are institutionally limited because their role is to decide things that, cases and facts that come before them. Their role is not to come up with the solutions for everything. So large scale reform is not the role of the courts, that's the role of governments. But in some respects, that's kind of how Section 35 has been treated. And of course, the courts are going to deal with these things on a limited case-by-case, piecemeal basis, because that's the nature of what the courts do. And judges are also by nature a fairly small c conservative bunch too. So they're not going to, make huge declarations about what it is governments are going to have to do. So what we've seen instead is, although the courts have vindicated Aboriginal rights under Section 35, it's been limited, it's been narrow. They're only ever a few paces ahead of the government on some of this stuff, and I don't think they want to go much far beyond that institutionally, and also just because the nature of lots of judges and lawyers is to be fairly small c conservative. And so that's why we get the problems that we do on Section 35, limited recognition of the inherent right to self-government, the things that I mentioned earlier, and TRC saying that the implementation of 35 and its interpretation by the courts has not met reconciliation. So we know these problems, we saw them earlier. And so I think that in addition to those problems, the other sort of contributing factors here is that, again, Section 35, the recognition of Aboriginal and treaty rights are hereby affirmed. It's so broad. It doesn't specify the kind of rights that Indigenous peoples are entitled to and that governments have obligations towards, or it doesn't specify government obligations either. And I think that that's just been a huge challenge, particularly to a judiciary and to politicians that really are coming from a very different Euro-Canadian perspective, and sometimes, steeped in we're all steeping in colonial tea, and so, coming to it from a position where if you do, take for granted that the Crown is, has absolute sovereignty and absolute control over lands and peoples, then you're not going to really see this very broadly, right? And so the imagination around what Aboriginal and treaty rights has been fairly limited because of the people who are interpreting it. So those contribute to the problem around Section 35. So what I argue is that Section 35, like every other provision of our Constitution and like most laws, is not written in stone. Laws are, created by people, interpreted by people, and can be changed by people. There's no magic to it. It doesn't require a constitutional amendment. People have interpreted Section 35. People can interpret it in a different way. Essentially, is my argument. And sometimes I have students who are just like, "But it's the way it is." I'm like, "No, it's not. We change our constitutional interpretations all the time." There's, you might remember from a few years ago that we struck down, our courts have struck down things like the laws on, some laws on prostitution, assisted dying, all sorts of things. The courts do strike down laws, and they do take new and different interpretations. They say that our Constitution is a living tree. That means it's not frozen in time, and it's capable of growing over time. And so my paper uses that sort of language of a living tree, and I do think that the UN Declaration can be a sort of breeze that comes along and helps grow that living tree and, breathes new life into it. And what I think is really great about it is that, the UN Declaration is about, the fundamental rights that Indigenous peoples are entitled to both collectively and individually. And, basically specify exactly the types of fundamental human rights that Indigenous people are entitled to. And it's super comprehensive about it. So it sets out those rights as well as what government obligations are in very clear enough. They're phrased at the level of principle, but far clearer than what we've been working with under Section 35. So my hope is that it now gets used to read Section 35 up, not having Section 35 sort of limit the purview of the UN Declaration. So, and that is the way that international law is supposed to operate. It is supposed to be the floor that informs our law. So if our law is here and the international floor is here, our law has to at least come up to there, and perhaps beyond. So I think that the UN Declaration will be really important for that. It really will, let's get to implementing, let's do it. I think I'm a realist, I'm optimistic, but I'm also a realist. It's gonna take a lot of work, but it's very clear that government has an obligation to implement, where it was less clear with Section 35. Maybe it ought to have been, but it wasn't. The other great point is that the Supreme Court of Canada has and can overrule earlier precedents. There's a test for this, but if a new legal issue has arisen, or there's been a change in social or legal circumstances that have really kind of fundamentally changed things, then the court is entitled to overturn earlier decisions. And so I think that the UN Declaration provides a very strong argument that there's been some real changes in the game, and that it's time to review some of the more problematic precedents that we have around Section 35, and some of the limits on rights that have been recognized or have been imposed. Coming back to the very beginning of my presentation, I also think that more implementation of the UN Declaration will put a great emphasis, much more emphasis on self-determination and the right to self-government. It really is the cornerstone of that instrument, and it's reflected in many other principles. It also says at various parts that Indigenous peoples' laws and Indigenous peoples' institutions have to be resorted to in order to implement particular rights. And so there's scholars who have said, like, this is just going to have a massive impact on the recognition of Indigenous legal orders and Indigenous laws. And that will be excellent. There's been some work in the last 10 years, as I alluded to briefly, but this might be the real shot in the arm to really move some of this really phenomenal work forward. On Indigenous people working to revitalize their legal systems. And I've been doing some of that work, and I can tell you it's the most exciting stuff I do, by far. Yeah, did I feel like I skipped perhaps a point or two? I guess that's sort of it. I think, and I guess what's missing here is that I will touch on before going to that last slide is the UN Declaration itself actually has specific provision, or the preamble says that any legal doctrine in a state that is based on the notion of racial superiority is illegal, immoral, and should have no basis in law. And in the legislation that Canada passed, implementing the UN Declaration, in the preamble of that act too, it says that any similar language, any doctrine that has its basis in notions of racial superiority are no longer legal and are immoral. But I do think that those two are really important provisions that we can then use to attack that doctrine of discovery, right? And use it as a basis to say, like, that these doctrines can no longer be the legal underpinning of, Canadian society. And a lot of our case law on Aboriginal rights. So, so I think that is another really important reason. And so we don't need a constitutional amendment. I think what we just need is goodwill and some stronger instruments that help us imagine what are the rights that Indigenous people have, and also compel governments to be implementing them, and that Indigenous folks and their allies and supporters can then be pushing on governments. That's my last point that I'll end on. Whoops. I don't think it's going to be a panacea. It's not a magic bullet. It's going to be a lot of work. I think politicians often, sometimes are well-meaning, but even then sometimes really don't understand the depth of what needs to happen and try things and sometimes they do not go well. And so there will be weak efforts. There's going to be problematic efforts to implement the Declaration and the Act. And so there's a lot of work to happen. But that doesn't negate the fact that this is a really important instrument, I feel, that can be used to really help undo a lot of the problems that we're still significantly grappling with. And I think it's going to take efforts by governments and also Indigenous people and their allies to continuously try to hold governments accountable to implementing these. I didn't speak about this at all, but this is just Canada we're speaking about. The government of British Columbia passed its own legislation on the UN Declaration. I think every province should have similar legislation and be going through a process of attempting to ensure that its laws are consistent with the UN Declaration. I don't know if our current government in Nova Scotia would be super jazzed about this. I certainly know New Brunswick's won't be, but it is another area to work on as well in terms of advocacy. So that's all I have. I spoke to you long enough.
So we could just take a second for him. He's going to do a thing.
I don't think he's running away with my gift. In fact, he just left it over there. So, thoughts, comments, questions, and no question. Even if you feel like, oh, geez, I don't know if I should answer that question. Just feel comfortable to ask a question. I won't say that any question is off limits. Go ahead.
So my question is about when you started the presentation, you talked about the difference between Aboriginal law and Indigenous law. So what I'm wondering is, a lot of this seems to be very framed around like the Eurocentric idea of what law is supposed to be, rights, that came out of the Enlightenment and that kind of thing.
Yep.
How much of I guess the UN Declaration and other policies, how much of that has Indigenous law as its basis instead of the Western version? Does that make sense?
I think, so what kind of role is Indigenous law playing in some of this
so
work?
so as we move through the kind of timeline, it's a bunch of, it seems like it's a lot of like just asking for different versions of a westernized version of the human rights approach. But what's the difference between that kind of Western version of approaching law and rights and something that's based on
Indigenous legal orders?
Indigenous legal orders, and can those two coexist? Can they become part of the same framework, or do we have to think of something completely new?
I think it is possible. I mean, not everyone is of the same mind. There's some theorists, Glenn Coulthard come to mind, and some others who are somewhat weary of trying to engage with the state in order to negotiate one's emancipation from the state. But there are some other theories. A wonderful writer in this area who's really sort of the foremost thinker in this area is a guy named John Burroughs. I mentioned him a couple times, but he's got an excellent book. His book, Canada's Indigenous Constitution, really sort of sets the stage for the sort of thinking through the role that Indigenous law can and should play in Canada. And it is informed, they come from, different perspectives and they can be informed by a variety of sources. It's not just traditions, it's not just customs. There's some really fascinating work happening in this. But also, some of the theorists working here are saying that it's not just necessarily rights that or laws that only existed pre-contact, right? They're not frozen. They can evolve, and if a group wants to meld practices that come from the past or traditions with more modern things, and if they want to write them down in a statute, they can. They don't necessarily have to. Indigenous law can be written. It can be oral. So there's different sort of discussions about that. And I think a lot of theorists would say that they can coexist, and there is room in Canada for them to coexist. And in fact, Canada already is a sort of pluralistic nation. We have Quebec civil law, and common law that coexist. And we have all kinds of other bodies that pass laws, and we have rules for how they can coexist and what happens when a law conflicts with another law. I don't think any of those problems are insurmountable, I think, and sometimes there is overlap and sometimes there are differences. And I think, but hopefully getting at a bit of what you were trying to figure out. Read John Burroughs. If you're really interested in this, pick up his Canada's Indigenous Constitution. Start there, and then once you finish that, email me and I'll send you a bunch more stuff to read.
Can I just ask, I'm assuming, this is like sort of a two-parter. I'm assuming that Indigenous self-governance would have a massive impact in general on Indigenous well-being and health.
Absolutely.
Okay. The other part of that is, how optimistic are you about
cases? Now, the U.S. immediately didn't change overnight, and they had their long history of industrial schools and attempting to eliminate reserve land and Indigenous people in the Trail of Tears. So I'm not saying the U.S. is perfect. But since the 60s, tribes in the U.S. have been relatively successful using that case law from the 1820s, but then also working with government, members of Congress, to bring a whole suite of bills. There's like 45 different statutes in the U.S. that touch on tribal. It doesn't give them the right. It recognizes tribes' rights to exercise self-government in a whole host of areas, from child welfare to education to all kinds of different service areas, but also in environmental areas, clean water, spousal abuse. Anyways, there's also a great article by John Burroughs on looking at how the US has created a sort of a legislative mechanism whereby rights can be implemented. So I am optimistic that this could be very much a useful model. I think the way to do that, I gave a talk to senators a couple of weeks ago, or last week, and I was like, you can use the power that the federal government has over Indians and lands reserved for good. I said you can use your power for good and not evil by passing legislation like the US has done, which doesn't control the tribes. It sets out legal frameworks in which how the funding will work is covered. What is the areas that these laws can be, the jurisdiction is recognized in. It's just sort of setting out a framework for how different things can work. And although nothing is perfect, it seems to work relatively well. I hope to learn a little bit more, even more about it. Canada passed finally in 2019 its first piece of legislation that looks like the US. In fact, it was modeled on the US, similar legislation in the US. So I mentioned child welfare earlier and how it's the massive area of inequality and underfunding, and we had a major Canadian Human Rights Commission decision in 2016. There's still issues ongoing there, but because of that, Canada was persuaded, and the TRC has talked about the massive overrepresentation of Indigenous children in state care and how that has to change. So Canada was persuaded to pass this legislation that does two things. It sets sort of national standards across the country when it comes to Indigenous children involved in the child welfare system, which is needed. But it also then recognizes the inherent right of Indigenous governing bodies, that's the term used, to create their own laws in this area and to have their own courts. So that got passed in 2019 and it's been in effect since 2020. There's, I think, 2 groups now who have passed their own legislation in this area. And I think that's a model, but I think it has to take off in the same way that the US has. But here's something exciting that fuels my optimism. So the bad part is that a government or a province in Canada challenged it. Guess which government in Canada might have challenged this law? Pick one.
Alberta.
What? Alberta? Close. Quebec. Who said Quebec? You win. Oh, you knew. Somebody said Quebec. I thought I heard that. It was Quebec who challenged the legislation. And we went to court on it, and I was there arguing for the First Nations Caring Society on behalf of Sydney Blackstock. And I think we're all feeling fairly optimistic that it's going to be recognized that Canada has the jurisdiction to pass legislation like this, including legislation that recognizes the inherent right to self-government and sets out sort of frameworks upon which these can be, that these rights can be recognized and also hold other governments accountable. So I think we were getting to the beginning of a start of potentially a model that I think could be very effective. So I think this idea of sort of legislative reconciliation and sort of the government's doing this. And Canada has been talking about passing a similar bill in health and a similar bill, I think, in policing. And there might be more areas coming down the pike. So I think that's good. I mean, there's still problems. Canada's doing some of this, like it's passing the legislation, but then it's saying, well, we're not really sure how much of it we're going to fund. Like, so there's problems, right? We also need legislation that helps us really hold Canada accountable to its funding. But nonetheless, we've got currently an administration that is at least willing to do some things, and we're being able to move pieces, I think, in a way that's not been able to move before. So it gives me some optimism. I'm very optimistic. My Mi'kmaq name is Rainbow, so I kind of see the world that way.
Anybody else have a question?
Back in the beginning, near the beginning of your presentation, I think you said Nunavut has a public government,
Yeah.
not self-government.
That's right.
And I wondered what that meant.
Sure.
And why not self-government at that time?
Sure. So when did Nunavut become a territory? 92? Thereabouts. It was 92. I was 12. I think it was around that time. So they were one of the earlier negotiated agreements. Now, at the time, there wasn't the self-government policy that then came in 1995. But they did have, there were some groups before. There was the Quebec, Cree, and Inuit that had negotiated the James Bay Agreement in the 70s. So there was an option to either sort of be a more self-government, sort of in relation to their members, or becoming a public government and creating the new territory. And the thinking of the Inuit was that, well, we kind of make up 85% of the population. So even if we had a public government, meaning they have a government that looks a lot like the provinces or like other territories, right? They have an elected government, and they kind of sit like our legislative assembly does. They pass laws like our legislative assembly does. So they kind of follow, for all intents and purposes, maybe to your sort of thing, a model that looks pretty Western and Westphalian. But they're kind of still doing some neat things. I wrote this paper this summer about the use of Indigenous languages for revitalization of Indigenous laws. And I studied what's happening in Nunavut a little closer. And they have many, many laws that incorporate Indigenous legal concepts in them and require that, even though they're written in English, they have these Inuit legal concepts written in, and they have to be followed. And there's like committees of Inuit elders and knowledge holders that are consulted in the interpretation of it. And there's a whole bunch of even legal cases coming out of Nunavut where you get, often it's still a lot, mostly non-Indigenous judges, non-Inuit judges, but there's a bunch of criminal law ones where you get a judge who's lived in Nunavut for maybe 20, 30 years. He's applying Indigenous legal concepts in interpreting the Canadian criminal code. So it's really fascinating. And so we are seeing this sort of melding of two legal orders coming together and coexisting in an interesting way. So in some ways it's sort of kind of playing with the two, but so Nunavut's a really interesting example where in some ways they're sort of operating within sort of Western paradigms, but bringing into it some Indigenous stuff. But there's still issues. Like I've talked to people from Nunavut who are, somewhat, still dissatisfied with a number of things about their public government. Some wish they had gone more the self-government route, but it's still an interesting sort of case study, and we'll see more of what comes from them.
Well, if that's it for the questions, and maybe we can do our little closing.
Okay.
Oh, sorry.
I was wondering what could we do to hold governments accountable?
Yeah, so thinking about this a lot, I do think we have elected governments who can pass laws, right? And so as citizens, I think we should be calling on, there's all the things that we're doing within our own, our universities, our social groups and things. So those are all great things that people are doing. So that's not to say that, there's ways that we can do that. But I think as engaged citizens, there is the pressuring of our elected officials to actually be taking steps to passing more legislation, like I forgot your name, Maz's question? Yeah. Mal's question. But like more sort of engaging in legislative reconciliation. In Nova Scotia, maybe, I don't know if the Houston government's going to go for it, but passing their own UN Declaration implementation bill, that would be kind of cool. Actually, I'm talking with Claudia Tinder about that some point soon, and some other folks, hopefully. I would think that maybe asking our governments to be more accountable and to actually be passing legislation. I think that with that legislation, it shouldn't be unilaterally passed either. Like all of this has to be kind of co-developed with Indigenous people. If I didn't say that, I sort of implied, but the work that needs to happen has to be done in consultation and co-developed with Indigenous people. And there's some work to do about how you do that well and what that looks like. But I think that could be a significant one, as well as the work we're doing within our institutions to make people more aware of issues, learning issues, reading more, learning about Indigenous law. So, yeah.
Anybody else for a last official question?
I've got another question. That's okay.
Good.
So I think it was last week, maybe the week before, that we saw the RCMP go into the Wet'suwet'en. I don't know how to pronounce it. The
Wet'suwet'en, yeah.
Yeah. Camp and start arresting people in order to drive the pipeline through.
Yeah.
So I guess my question is, we've talked a lot about like the role of the state and different forms of law and their histories. Is there a space here for, I don't know, I guess the other players like private business, or what people would say, the business world or private enterprise? Because to a large extent, the government in that situation is supporting the oil producers,
Yes.
the oil refineries, and people who build the pipelines. So I'm guessing. So I'm just wondering, what effect do they have on the legislation in this subject in Canada? And is it
Yeah.
similar to like the States where like people say like there's like a corporate oligarchy that controls the government to a certain extent? But
Well, what do you think? I'll turn that question back to you on that one.
I would say, well, I don't know. I'm very much a leftist, so I would go like yes, huge influence.
Yeah, and and I think that's going to be some of the hardest issues, the land issues and resource issues. And I mean, I think child welfare in some respects, even though it was challenged at Quebec, is a almost like an easier way to start to drive that door open. But like issues of land, especially with capitalism being what it is. But capitalism is in some ways. Having to also grapple with climate change and issues of income inequality. And I think like these are all issues that are sort of putting pressure on capital, whether there'll be any massive dramatic changes as a result of it. I hope, but I don't know. But I think, so for example, in the Wet'suwet'en case, there was actually a court case where some of the land defenders had actually cited Gitxsan law or Wet'suwet'en law as part of their defense. And in a decision that was highly criticized, the judge was like, yeah, we kind of recognize Indigenous law currently in Canada, but it's still really nascent. And so I won't really deal with it in this application. And that was criticized harshly by the Indigenous Bar Association and some other Indigenous scholars and non-Indigenous scholars. So I would maybe hope that the introduction of Indigenous laws and its recognition in Canadian law will hopefully help in sort of achieving that balance. I think there's other things that are pressuring our move away from mass extraction and fossil fuels and all of these things. But I think that our law is also capable to change. Law is slow moving, but I do think that there is room in there. I teach a case to my students. It's not about Indigenous law, but it's about unions picketing and how Canadian law for a period of time prevented any type of picketing outside of the employer, right? So it's called secondary picketing. It was a common law rule, and the Canadian common law is the handmaiden of capitalism. Let's just be clear about that. But in a court case, the Supreme Court said, well, charter values, and there it was sort of the right of the union to picket and to protest, and that was protected by freedom of association as well as freedom of expression, meant that this rule that really protected secondary businesses from having any protest or picket, they said now we've got to balance these differently. That there's got to be only if the protest or picket is causing harm, like some other type of tort or criminal law, then is it a problem? So it was some sort of balancing of the law, I guess is what I'm trying to say. Not that was a perfect solution in that case, but I do think the law is capable of sort of changing and balancing and bringing in other sort of values that could be counterweighting. But it's not going to be easy. So I don't know if I answered that one as well as I could have, but some thoughts on that. But I know that I'm very optimistic, but I think that that's going to be a huge challenge. But I think we've got more allies now than perhaps we've had before. I think it's in a lot of different groups' interest to be working together against big companies and the massive laissez-faire capitalism. Sam?
All right, I guess what we can do is the closing now, and then I'll just mention last thank you, and actually we have an evaluation that we'd appreciate if anybody would care to just take a quick give some ideas about how to do this, maybe do another topic or something like that. And those are right up there on that table. But anyway, I introduce Andre Caleo.
Hi.
Hello,
Hello.
Quay, bonjour. Am I both on camera here?
Yep.
Oh, okay.
Here,
Oh, don't fall over.
well, hello everyone. I'm Andre. That's my GST name. Ojibwe people gave me my name, Ajakakio Mutik. It means, translated loosely, my spirit is like the oldest tree in the forest, for what that's worth. So you mentioned rainbow. You truly are a rainbow, Naiomi. I mean, you're shining, your spirit shines out of you
Oh,
in
thank
brilliant ways of charisma and beautiful energy and
Thank you.
your passion for this. Wow, blow me
Thank you so
away.
much.
So I'm going to do some thank yous. Red Bear, Healing Home, in no particular order. A lot of people did a lot of hard work to put this together. Charlotte, Mal, Jack, Carla is outside there with Haley at the desk, and Matza, who's not here this evening. So I thank all of you, without you. All of the people that came here. Wow, there's Haley. I'm sorry, I thought you were still inside. So like, yeah, 5 people, whatever. You know what? 5, 50, 500, it doesn't matter. Like this thing here is going out on the internet. It's being recorded. So maybe 5,000, right? 500,000, 5 million people. Who knows how
And
many
that's
people?
optimism.
Right. So yeah, it's getting out there. The message is getting out there. I'm not going to speak too long, I promise. I don't have any notes. I just do it from the heart. So, I mean, these are all thank yous, right? All of you people came out here and put all this together. So, without you. Naiomi, wow. Like, that was so much. You know,
I have I'm a little bit overly comprehensive. It's
No,
something
it's
I'm
great.
trying to work on.
and, you know, I mean, I'm kind of partly knowledgeable about what you spoke on. So many things I had no awareness of at all.
Yeah.
And so it's being recorded, so I can go back and go,
Yeah.
okay, what was she talking about
Yeah.
there? So, I mean, that's a miracle of our modern
There
technology.
you go. And I'm also reachable by email, so if you had a question or any of you wanted to reach out and just ask about a resource, happy to oblige.
Thank you. Yeah, you know, we don't give up hope here, right? I mean, this has been going on 500 years.
Mhm.
And in my time, I've seen changes, and it's slow, snail's pace. You do have lots of allies.
Mm-hmm.
There are people like myself and others here, I won't name any names, but you know, we're all there behind the scenes. Prayer, the power of prayer, I'm sure you know all about it. You know, and I go into the Sweat Lodge and I pray that our leaders, our corporate and political leaders who have way more power than little people like me, you know, open their hearts and minds to see, you know, the truth of our time, right? We are all children of this Mother Earth, right? My elders passed on now. He used to say, you know, there's only one race, that's the human race. And here we are on this bright blue ball spinning freely through, you know, wow, blow me away. Right? So anyway, yeah. And I think, you know, time has changed, right? We're gonna do what we all work together on this. Every single one of us has a part to play, big or small. So, and your part, Naiomi, is like, wow. Your passion and dedication and like energy coming out. So
Thank you so much.
So we're not in ceremony here. There's in our way, in Mi'kmaq way, and other First Nations people, you give a gift, and tobacco is in here, one of the 4 medicines, and some other little things. So we hold it up to the Creator first, in the left hand, and offer to the left, and say without you. And you know, the white man likes to take your hand and squeeze it to death. You know, it's like, yeah, I'm bigger and stronger than you are. You know what we do? You take the person's hand gently, you feel that person's spirit, and you say, wow. Right. Anyway, I'm not going to go on too much longer. I'm just not lying. All my relations.
Thank you so much.
And last
Thank you
thank you to Naiomi. And,
Thank you.
for doing that.